Hi, everyone. I am Beth Rebay, the Director of Repair, which sponsors the Civics Project, and I'm also today's co-host of the Civics Project episode 42 on abortion. And I'm thrilled to be joined today by my wonderful 13-year-old goddaughter, Naomi, and we'll hear more from her in a moment. Before we do, I just want to start with a brief land acknowledgement. Repair acknowledges the Tongva peoples as the traditional land caretakers of Tovangar, the Los Angeles Basin and South Channel Islands. And we are grateful to have the opportunity to work for the Taraha Tone, the indigenous peoples in this place. We pay our respects to Hanukvatam, the ancestors, Ahihiram, the elders, and Eohinkam, our relatives and relations, past, present, and emerging. So I again want to welcome Naomi Cross, my co-host, and ask you to tell us more about why you chose today's topic. Naomi picked our topic for episode 42, which is again on abortion. What made you decide this should be our priority today?
So I chose abortion because it is becoming increasingly controversial. And I heard yesterday as we were preparing that the governor of Texas insists that there is no need to have an exception for anti-abortion laws for rape victims, including teenage rape survivors. I'm 13 and I'm really grateful that I have not been sexually assaulted, but I know that girls my age are sexualized and really young. And sexual assault is prominent in teen girls, both by teen boys and adult men. It's extraordinarily common. The idea that something so terrible could happen to someone my age and that they could be forced to go through a pregnancy and a birth is really awful. And it's so scary because youth bodies are also not really ready for pregnancy in many cases. And many girls who go through pregnancy would miscarry or suffer injury during birth. And I'm not old enough to vote. And I think that it's a problem that people who seem to be very not smart or very cruel are always the ones who are in power and make policies for people my age. And the problem is that I feel like we need to have a lower voting age as well. So if adults can't be trusted to make safer policy for kids, then more of us need to have a voice in our elections. And so Beth, I have a question for you. So what has the history of abortion been in the US? Like, how did abortion become political, and why can't people just have health care?
Okay, good question. So the politicization of abortion has a number of roots in US colonial history, before and since the Revolutionary War. So there are a number of ways that I could answer that question, but I'm going to focus on the 1850s. And really moving in that direction in the 1840s, but particularly the early 1850s. And a lot of the blame, unfortunately, rests with the American Medical Association. And the reason that they started to sort of get very invested in making laws around abortions was that at this point in their evolution as an entity, they had recognized that they were losing a lot of prospective business to midwives. And they were trying to figure out, how do we make it so that people will only come to hospitals, to gynecologists, to get medical care and not have births at home or have independence of medical institutions when having babies. So they wanted to figure out, how do we get rid of our competition? And one of the things that was true at the time is that midwives could abort a fetus if someone wanted that done. And it was something that, again, you didn't go to a medical institution. You would pay, a midwife a little bit of coin or goods. So there was a lot of barter, and she could abort a fetus, either wherever she was working or come to your home and do it. And that was how people had abortions, and had been having abortions essentially throughout early US history and beforehand during the colonial period. So obviously physicians didn't want to ban pregnancy, right? That wouldn't go very far. But to put the midwives out of business and get control out of pregnancy, one of the things they decided is, we should make it criminal to have abortions. And if we do that, that gives us a basis to have midwives arrested and not allowed to practice. And so the American Medical Association started to lobby for policy about it. And they needed an argument to make about why abortion should be a crime. And they teamed up with, the mid-19th century version of the Christian religious right, and, try to advance arguments that giving an abortion, receiving an abortion is a crime on moral and medical grounds. And so that's when we started to see the more mainstream passage of anti-abortion laws in the United States. And Naomi's smiling right now because my cat has joined the podcast. This is Harriet. And once we saw abortion become criminalized, it did have the intended effect, which is over a generation or two, it radically reduced the presence and normalcy of midwifery in the United States and helped establish a new social norm in which people understood that they had to go see a male physician. And we want to remember this was at the time where you couldn't really find licensed women doctors anywhere. So physicians were by definition male, and there were virtually no, if any, male midwives, right? So this was a very, very gendered process, get women out of reproductive care and put it solidly back in the hands of the AMA. And in addition to sort of a profit motive, I think part of what was also driving the American Medical Association at the time was, a sense of the fact that, again, they didn't want women competing with their expertise. And they also really brought race into it, arguing that midwifery was, these examples of these sort of heathen or savage practices, that midwives were, people who were engaged in racially deviant and problematic and uncivilized, kind of folklore. And they, tapped a little bit, not too heavily compared to earlier periods, but they tapped a little bit into rhetoric from earlier US period associating midwifery with witchcraft, right? So the basic message was that midwifery is associated with savagery, meaning with people of color, and it's about women stepping outside of their proper role, which apparently meant that women should not have any control during the reproductive processes. And so those, sort of expressions of sexism and racism, coupled with religious right ideas about sort of the civilization and God and males being the proper authority figure in areas like medicine, all came together. And it took time for people to have the notion that abortion was about saving the life of a baby, right? So that wasn't really a very meaningful political debate. You bring up abortion right now, and the first place people go are questions of when does life begin, and is abortion murder of a baby, or is it termination of a pregnancy? And right, all of these really charged debates that we live with now weren't normative in the 1850s. There were some elements of them, but it just wasn't something that was really on people's mind. So the AMA helped to politicize the issue over time, and isn't solely responsible. Various kinds of politicians and religious sectors played a role, but eventually this became, understood as a major moral issue. And I think it still wasn't as loaded throughout the late 19th century and 20th century as it really became in the 1970s, when the second wave of feminists started to push more deeply for a right to abortion. Up until then, the policies set in place by the lobbyists, or the early versions of lobbyists from the American Medical Association, had evolved over time and been reincarnated and reinvented in various forms in different states, but had basically operated on the same set of presumptions and principles that had been true in the 1850s. And so when we start to get to the second wave of feminism, this is the first time, not the only time the issue's been raised, but the first time that there's a strong enough public political challenge to potentially change policy, which is what actually eventually happened. Does that answer the question?
Yes, it does.
In a nutshell, you can blame the AMA.
How did the idea of abortion rights come about?
Okay, so it was a core premise or focus of what we can think of as late 60s and early 70s to mid 70s, second wave feminism. Most of our listeners probably already know this. We refer to the second wave as the period of advent of feminism, right at the sort of tail end and emerging directly out of the civil rights movement. So late 60s into early 70s. And one of the core issues that was identified by feminist groups in this era as critical was the ability to end a pregnancy. And at that time, this became sort of a mainstream focus of feminism as an emerging movement. Later, advocates would start to critique the limitation of the issue solely to abortion, saying what we really should be talking about is reproductive justice in a much broader frame, which can include sterilization, contraception, prenatal care, postnatal care, sexual, and reproductive safety, and just and care for new mothers, working mothers, the ability of parents to support and bond with children. So really conceiving of both families and sexuality in the process of reproduction as a much more expansive issue. But in the 1970s, abortion was what folks were really talking about. There was some attention as well in this period to pregnancy discrimination in the workplace, and some early pushes for family and medical leave, for maternity leaves, and eventually parental leaves. But abortion was definitely among the most central and among the most controversial aspects. And so that term abortion rights basically belongs to that era. And a few things that I think are interesting to know about this time period. One is just that, there were multiple pushes coming out of the second wave of feminism to figure out how women could have more reproductive autonomy. So those of you who are familiar with that period may know the term consciousness raising, or CR, which referred to groups of second wave feminists who would meet and talk sometimes in great detail. The consciousness raising as a method had actually been adopted from the civil rights movement, but feminist consciousness raising groups really spread around different parts of the country. And the basic idea is that people would come and narrate their life experiences, and then whoever was facilitating that particular group or the group as a whole would work on figuring out what were the commonalities of their experiences and how could they understand where their personal experiences were actually connected to broader gender politics. So getting a little more deeply at the question, the sort of why of it, I think was located in that era. That is, women got together to talk. A lot of what they were talking about is the inability to have control over their own reproductive processes. And they were exploring what to do about that a few ways. So some were advocating for policy, which eventually, and doing a lot of grassroots work in that respect, which helped bring about Roe versus Wade, the 1970s era decision on abortion, which basically made access to abortion, at least in a limited way, a constitutional right. Others were really exploring, like, what else can we do that's just about, learning our own bodies. So at the time there was a technique. This is an interesting one, Naomi. It's called menstrual extraction. And it was a way that women could get together in groups and learn how to basically extract their menses using, basic, no surgery or anything, no opening anybody up, just how to go in through the vagina and extract the menses and bring it out all at once. And one of the consequences of that is that if you did that in a particular month, you wouldn't have to go through bleeding for several days having a period. I think this is an interesting one to talk about with Naomi, because she's really interested in menstruation as a social and political issue. So 1970s era feminists were learning how to perform menstrual extraction, which gave you a way to basically remove your egg before you would normally menstruate, so that there wouldn't be a possibility of pregnancy in that time period. So one of the things that folks who are involved in the women's health branch of the second wave of feminism noted is that when Roe v. Wade passed, everybody sort of relaxed and took a breath and said, okay, great, we can have abortion rights through medical care. And so the efforts to sort of figure out how to get control more directly, mostly died in that era. So that's an answer. Does that answer the question, Naomi?
Yes, I have another question for you, and that is, what rights do women have under law right now?
Okay. So I'll focus, we could answer this question a lot of ways. I'll focus on federal law, particularly constitutional law, to start, and then just acknowledge a couple other things quickly, because it's a complex question. So we won't have time to totally answer it. But basically, our doctrine right now creates a certain basic and limited right to access abortion, which the Constitution protects individual women from having eroded or interfered with to a significant degree by states. So I'm going to unpack exactly what that means. The Constitution basically says there's some precedent in law, even though the word privacy doesn't exist in the Constitution. And for those who'd like to know more of that history, we have a prior episode on the right to privacy from a few months ago. So the court basically referenced prior constitutional decisions that had acknowledged the right to privacy as embedded in the 4th, 6th, and 14th Amendment, and possibly the 9th Amendment as well. So the courts recognized, even though the Constitution doesn't say privacy, it's bound up in, it's implicit in the meanings of various amendments that we've ruled on before. So they said there's a constitutional right to privacy. And again, this wasn't the first time the Supreme Court had ever done that, but it was still a relatively new idea and wasn't explicitly written in the Constitution anywhere. So they said you have a right to privacy. And then they said, the state poking into a decision you're making with your doctor erodes that right to privacy. So basically they said the state should not get in the way of something that really should be a private matter. And that was at the core what the Supreme Court decided in Roe versus Wade. And effectively what it did then was overturn laws in a number of US states, which allowed the state to intervene by doing things like making abortion a crime or putting lots of restrictions on when you could access it. So Roe versus Wade basically said states don't take away and don't interfere this much with a woman's privacy. Right? That was the outcome of Roe versus Wade. And subsequent Supreme Court doctrine interpreting the same issue basically said, well, okay, let's think about when and how do you, would we say that the state is really interfering to the point where they're taking away some constitutional right? So what the court basically said is, okay, it shouldn't burden women's right to privacy too much. So, but that meant that it could be a burden on women's right to privacy somewhat, right? So this is essentially what the court is deciding and discussing in later decisions like the famous Casey decision, which affirmed Roe versus Wade and also gave us a better sense of what its limits were. So, and that's Planned Parenthood versus Casey specifically. So what the Supreme Court has said is you do have a right to make a private decision about whether to have an abortion, but not every state law that interferes with that right is considered too much. You have to establish that it unfairly and unduly burdens your right to privacy. Otherwise, states can legislate things like waiting periods and whether or not the abortion can be paid for, and can do other sorts of things to restrict the right. And I want to be clear that the Constitution doesn't say you have a right to be free from the government doing anything to force you to give birth, right? So there's nothing in the Constitution that says you have a right not to be forced to be pregnant. Right? What the Constitution does say is you have a right to privacy, and this is a private decision. So it was always sort of a precarious compromise that the Supreme Court made in Roe versus Wade, right? They didn't fundamentally declare that abortion is a right. They just said, well, it's a private thing, and the state shouldn't invade your privacy too much. And then later they said, well, they can do some stuff. They just can't really, really, really invade your privacy way too much so that you couldn't have an abortion at all ever. And in an oversimplified nutshell, the history of federal jurisprudence about this has been about different states and jurisdictions testing the question of when is it too much interference? How much can people get away with? And meanwhile, at the state level, we have different states trying different things to sort of chip away at Roe versus Wade. And that's been happening for a long time. And those cases keep getting challenged, sometimes in state courts, but often in the federal courts under the 14th Amendment right to privacy as it exists now, and as was the foundation for Roe versus Wade. And so that is sort of where we are, which is there's a sort of significant, but also fragile and precarious right to an abortion currently grounded in the 14th Amendment. And just as the Supreme Court shifted away from prior policy by just declaring first that privacy was a right, and second, that abortion was a private issue, there's nothing other than public pressure that can keep the Supreme Court from just changing its mind now that it's got a new set of justices. So I just mentioned state laws, and one of those, as you know, is the recent Texas heartbeat law. And, this is a law that basically allows individuals to sue for $10,000 anyone who has an abortion or aids anyone in getting an abortion, not just abortion providers, but anybody who assists them in any way. And it even has some really sketchy language. I mean, it's a sketchy bill across the board, but it has some really sketchy language, which even says that the intent to help someone have an abortion is a basis for legal action. So if you intended to do something, even if you changed your mind, if someone had evidence that you had decided to do it initially, they could conceivably, as this law is written, take action about it. And so, the question now, or one of the questions before the Supreme Court around this Texas heartbeat bill is, does this place too much of a burden on women's privacy rights? And, we've seen courts sometimes say, yes, you can really delay someone's access to abortion. You can restrict it so that it's not available in certain geographies. You can refuse to have insurance policies cover it, and you can counsel people in ways that involve a lot of pressure, right? So we can understand there is a lot of precedent going both ways, but there's plenty of precedent that says you can really significantly interfere with someone's rights. So Naomi, I want to ask if you can tell us more about the consequences of heartbeat laws, right?
Yes.
The heartbeat law in Texas, right, is one that basically says that once there's a fetal heartbeat, essentially any sort of right to abortion is annihilated. And this is, I wouldn't say a brand new phenomenon because we have all of US history to look like this is a recent, there's a recent set of bills that have been passing that all have this same premise. So what can you tell us about the consequences of heartbeat laws?
Okay, so Ireland has laws on the books, like the new one in Texas. And recently, a 31-year-old dentist and pregnant woman, Savita Halal Panever, had sought out an abortion repeatedly because she was often in great pain and she was already in the process of miscarrying. However, because the fetus had not yet died and they were able to detect a heartbeat, she was not allowed to end the pregnancy. and she unfortunately had passed away, and an autopsy had confirmed that she did die as a result of the pregnancy.
Mhm. And so it's important that you mentioned Ireland because it's a country that's used heartbeat legislation for some time. So it's a significant case to look at what are the consequences. In the case of Savita Halappanavar is particularly heartbreaking because she was already miscarrying. There was absolutely no chance of a viable pregnancy, but she was denied life-saving medical care just because they could detect a heartbeat of the dying fetus. And we can imagine sort of what that would be like experientially. It hasn't been the reality in the United States for the most part. Those states do keep pushing it. But we can imagine how that would be to just basically have, to know that you're miscarrying and be in pain and know that you're not going to be able to give birth and still not be able to terminate the pregnancy. There's a cruelty to that that's really shocking. So thank you for sharing a little.
I have another question for you. So what is happening in the Supreme Court right now? Are they going to overturn Roe versus Wade?
Well, I'll be frank and say the simplest answer is yes. And the only question is, will it be just smashed and annihilated, or will it be significantly weakened, but some, fragment of it will be left? So there are two cases before the Supreme Court this period. One is the Texas law, the Texas heartbeat law. And I think that we'll see some negative action from the Supreme Court against that law. And the reason is because it has this really sort of bizarre and underhanded structure. So the 14th Amendment protects women by the state invading their right to privacy. Texas is trying to argue by creating a bounty which any private person can collect against anybody who's involved in abortion. The state isn't banning abortion. It's just empowering people to do so. And so their argument is that it doesn't violate the 14th Amendment, which is a pretty bizarre argument, but we have a very anti-abortion Supreme Court majority, so we can imagine they would accept things that might not seem like common sense to many of us. But even the very anti-abortion members of the Supreme Court are having some pause over the Texas heartbeat law. And an example of what they've been raised is, well, if we let Texas do this, could some other state like California or New York pass anti-gun legislation, which would allow people to sue anybody who, possesses a gun, right? And so, if that model allowing individual members of the public to collect bounties for private activity the state disapproves of were allowed to stand, I think we would see a lot of other legislation that the Supreme Court wouldn't really want to deal with. So for that reason, I think that there's a likelihood that at least some aspect of the Texas heartbeat bill won't survive Supreme Court review. I think it'll be at least partially overturned. I could be surprised on that, but that's my suspicion. I think that's where it's going. However, Mississippi has introduced another suit, which the Supreme Court has started to hear already. And Mississippi has basically passed a law which it knows from prior efforts is not allowed under the past 50 years of jurisprudence using the Roe versus Wade doctrines and the constitutional right to privacy. And they've explicitly passed this legislation and said, we're going to try because it's a different Supreme Court. And what they mean here is that in the very first interview that Donald Trump gave after his election in 2016, before his inauguration, one of the first things he said was that he intended to eradicate abortion rights and overturn Roe versus Wade, and that he planned to do that by seating justices who would do that work. And the initial nomination by Barack Obama of Merrick Garland had been stalled in the Senate. And so that seat wasn't filled until Trump took office. And then he was able to appoint Neil Gorsuch, someone we know to be both a fan of very right-wing justice, Clarence Thomas, known to be one of his staunchest adherents and devotees, and to have a strong track record against abortion. And then he got to seat the incredibly controversial Brett Kavanaugh, as we all might remember, from 2018. And then the Republican Party radically rushed through the nomination of Amy Coney Barrett in order to fill Ruth Bader Ginsburg's seat before the presidency potentially shifted hands. And they did so despite having stalled Merrick Garland's nomination, claiming that you shouldn't appoint anyone right before a major presidential election. So he got his 3 justices. He got 3 justices who might not side with him about everything, but who have a staunch and articulate anti-abortion history of jurisprudence, have written opinions and majority opinions, essentially, either arguing why abortion should not be understood as a constitutional right, or whether severe restrictions on it should not be understood as eroding those rights. Brett Kavanaugh is particularly notable on this issue. He heard a case involving a teenager who was being held in immigration detention and argued that being prevented from getting to an abortion provider would not unduly burden her abortion rights, and that waiting for several months also would not do so. And, you always have to think about how somebody imagines that it's not a burden to have a pregnancy continue till much later before getting reproductive care. And of course, Justice Amy Coney Barrett has been out there saying things like, well, if you don't want to raise a child, that's okay. You can give the baby up for adoption. So it's really not a hardship to have to go through an unwanted pregnancy. So what I can say is the climate is very, very favorable for a 6-3 majority to uphold the Mississippi statute, which is directly challenging and if upheld would essentially crash Roe versus Wade. And I think that will happen in 2022. And again, we'll see if the Supreme Court or the majority of the Supreme Court just outright says Roe versus Wade was wrong and we're doing away with it, which some of the justices we know, explicitly and openly agree with, or whether they'll say, well, we're not overturning Roe versus Wade, but we're going to reinterpret the meaning of the right to privacy to better prioritize the state's interest in being allowed to deny people access to abortions. So that's where we are. And once the Supreme Court makes that decision, there are 2 things that can happen. One is that the sort of battleground then shifts to the states, and individual states can get away with things that were not allowed under the 14th Amendment in the past nearly 50 years. But people can mobilize at the state and municipal level to try to protect rights. The other is that Congress could pass, reproductive rights legislation to try to reinstate the protections of Roe versus Wade and restrict states from passing anti-abortion legislation. The challenge with that is always when something is the understood meaning of the Constitution, it's very hard to change. When something is passed by Congress, all it takes is to flip the executive and legislative branches, or at least build enough of a coalition or support for your side, and it can be undone with a couple of votes and a stroke of a pen, right? So if abortion rights are only protected by the legislature, they're going to be a lot more fragile. And it's a question whether you could even get a 51 vote majority in the US Senate right now for abortion rights, given how tightly split it is. So Naomi, I want to ask you this. What do you think needs to happen? And I am wondering, would you ever consider running for office or becoming a judge someday in order to work on reproductive rights and policy?
Okay. I am a little bit intimidated because it seems as though Harriet is coming for my co-host position. But on a personal level, what you can do to help with abortion rights is you can create a film or share pro-choice content on social media. You can create a charity, march at your capital, or go to a women's march, elect more women in Senate or state offices. And at a policy level, government should fund healthcare for women and girls, gender nonconforming people, including access to abortion, care after sexual assault, prenatal, postnatal, contraception, give counseling and support for fertility, make clinics accessible, and add reproductive health care and insurance. And oh my God, that is an awesome cat.
Yeah, she's definitely joining us. So for those who are listening but not seeing the video recording, we've been joined by Harriet, my 10-year-old tabby cat. Thank you for that great list, Naomi. I'm serious about this question though. Like, would you ever run for office or would you ever try to become a judge?
I definitely would consider it. I feel like it's important to have fresh new views, and I feel like the new generation should definitely start to become part of our legal system. And so, yes, I would consider it. I feel personal responsibility to help change the world. And so I feel like, yes.
Yay, that makes me really happy. Well, you know, you've got an eager godmother to help mobilize votes for you if you ever decide to take that step. So Naomi, I'm wondering, for those who'd like to learn more, would you share a book recommendation for this episode?
Of course. So the book recommendation is Reproductive Justice, an introduction by Loretta Ross. It has Kindle and hard copy.
Okay. Thank you, Naomi. Definitely a good book to read. So I've mentioned as of our last episode that the Civics Project will be taking a hiatus. So you won't see us in January or for a while. We do plan to return eventually, and Naomi will definitely be invited to join us again when we do return. So thanks so much to everybody who has been joining us so regularly in 2021. It's been an amazing 42 episodes, and I'm really grateful that you have been here to share them. We're going to end our recording here, but for those listening, please like us and give us 5 stars and share. And again, to those who've been joining us and supporting us along the way, we're so grateful for you. And for our Zoom audience, we'll be happy to take more questions once we finish recording. Thank you again, Naomi.
Okay.